order. And we will start with the pledge. And there it is. Okay. I don't know what he's doing. Is he getting the real flag or are we going to use the one? He is. Okay. That's okay. Thank you, Manny. All right. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So we're going to do the roll call next. Commissioner Clark, Commissioner Roy, Commissioner Hybels, Commissioner Yun, Commissioner Sykes, Commissioner Lewis, and Commissioner Jones. And with that, we have a quorum, and actually everyone is here. Okay. So this agenda has items on it that we don't have any reports for. So we're going to go right into the presentation and workshop item. So as we let the council know previously, we were going to begin some of our presentations with special counsel and experts on individualized topics. So tonight is the first one of those presentations. I'd like to introduce to you Joshua Kienitz from Littler Mendelsohn. And Josh has agreed to be your presenter tonight on the topics of the Public Employee Relation Board, administration of the MMBA, the city's Memorandum of Understanding with VPOA, CAMP, and IBEW, and the Myers-Milius-Brown Act. So with that, and those topics will be your topics tonight. And then at the end of this meeting, we'll talk about your next presentation and confirm that date, which has already been confirmed by Dawn with all of you, I believe, and the topics for that presentation. So with that, I'm going to turn it over to Josh.
Good evening, everyone. It's a pleasure to be with you. And sorry I couldn't make it in person. I had some childcare duties that I am able to fit this into. But first things first, if anyone, actually, can you hear me or can you not hear me? How's it coming through? Okay, perfect. I will. So I'm an attorney with a law firm, Littler Mendelsohn. I've been doing this for about 20 years. I do labor relations. I do a lot of labor, so collective bargaining, charges with administrative agencies, arbitrations under collective bargaining agreements, and I work with public sector and private sector clients. But that's kind of my background. This is what I do, and I've been asked by Veronica and Randy to come and share some of this with you. As was said, the two kind of related topics, or maybe three topics that are related, that I've prepared a short PowerPoint on, are the collective bargaining agreements, or MOUs, that the city has with the three unions, the California law that governs labor relations between the city and those three unions, called the Myers-Milius-Brown Act, or MMBA, and then the administrative agency, the Public Employment Relations Board, or PERB, that is created or empowered by that law to enforce the law and sometimes the collective bargaining agreement. So you feel that if you have a question or want to interrupt at any time, I think that's your prerogative. Otherwise, there will definitely be time for questions at the end. So I just maybe ask Randy and Veronica, I could share my screen and go through, or someone there could do that, either way.
Hang on, Josh, we're rearranging. There we go. Better? Okay. You're not hearing him. Manny, can you increase the volume for Josh, please? Josh, can you say a few
Yeah,
words?
check. How is that?
There we go. Perfect. Thank you.
Okay, great. Um,
Josh, if you're driving, I
so I'm
think you
just going into full screen mode here. Okay.
got it. Mm. Manny's going to have to help again.
I've got the slides queued up if you want to just go with what we have on screen, Josh.
Yeah, I just would like trying to make it a little big. There, whoop, you had it for a
So
second.
that, I think that works.
There we
Is this-
go.
Can you guys see the big slides? So,
Yeah.
okay. So this is just the title page. And I think we've worked through the glitches. So thanks for bearing with me there. So this slide just lists the different bargaining units or the different unions that the city has memoranda of understanding with. The VPOA, obviously, for police officers, the IAFF for firefighters, and the IBW. And the IBW it's what's called a bargaining unit. The term bargaining unit is the group of employees that are represented by that particular union. The IBEW has a bargaining unit that is very diverse. So, and there's engineers, technicians, clerks. The IBEW bargaining unit is essentially all the classifications listed in that contract or in the IBEW MOU. Those three documents are binding contracts between the city on the one hand and each of these three unions on the other hand. And those contracts are binding for everyone in the so-called bargaining unit. For the VPOA, it's police officers. For the IBW, it's a variety of classifications, basically every classification listed in the contract. The
I have a question.
the wording of
Just
okay.
Josh, if I can jump in for 1 second. And so as relates to this body, the VPOA is obviously the bargaining unit for the sworn officers. It does not include the chief or the deputy chief who are not part of a bargaining unit, but it does include everyone else or all other sworn. I'm sorry, can you back up one slide? Oh, never mind, I have it in front of me. The IBEW also includes clerks within, so like our records clerks and other clerks within that do work within the police department. The dispatchers are in that bargaining group. The IAFF is not affected by this body, so this body doesn't deal with firefighters. So it's up there to let you know that's another bargaining unit we have. But that is not a collective bargaining agreement or MOU that is affected by this body. Sorry,
Thank
Josh,
you.
go ahead, take it away. I just wanted to
Yeah,
let them know who is in which group.
absolutely. Yeah, it's important information anytime you want to chime in.
Thanks. There's a question,
So
I
I have a
think.
question. Camp, is that one of the units that should be included on here or no?
So CAMP is a group that does have members within the police department, but CAMP is managerial employees and their rights under the CAMP bargaining unit are a little different.
But should they be part of the, on this in PowerPoint? Because don't they, some of them oversee these clerks that are part of
Yeah.
IBEW?
Right, they could be. Yes, that is correct.
Okay. Thank you.
Oh, whoops. Okay, Josh, sorry. Go ahead.
So listed here are some of the major provisions of nearly every MOU. There are provisions governing these issues in all three of the MOUs that we just talked about, and definitely also in the police officers agreement. A major one, when I say recognition, that's the recognition of the union as the exclusive bargaining representative. That's the contractual provision that makes it clear that on subjects of wages, hours, and working conditions, the city must deal with the union and generally can't deal with officers individually. The union is recognized as the exclusive bargaining representative. That's in every contract, and it's definitely in the VPOA agreement. Just cause for discipline and discharge. It's probably the most significant provision in a collective bargaining agreement if you ask most unions. If you were to explain to someone the difference between working in a unionized environment and working in a non-unionized environment, the term just cause is a requirement for anything that constitutes discipline under the MOU and or discharge. A just cause provision, those two words, just cause, attached to just cause is a variety of tests. And the test would be applied by someone called a labor arbitrator. We'll talk about the labor arbitrator more later on. But the test would be applied by someone called a labor arbitrator who essentially functions as the judge and the jury over disputes under the MOU. Just cause means not discriminatory, meaning not picking and choosing between treating one officer different than another officer if they both do something similar. Just cause means a fair investigation, a fair and full investigation. Just cause means that the rule at issue, whatever the rule is, was adequately known by the employee, not just in a policy, but you were trained on it. Just cause, under the just cause test, an arbitrator can rule on whether they think the rule is reasonable. The employer, meaning the employer, usually has to prove that the rule is reasonable. Different arbitrators break it down into kind of different numbers of tests, but the generally accepted concept is that there's 7 components of just cause, and what that provision does in arbitration is it puts the burden on the employer to show that a discipline, a warning, a suspension, or a termination was for, quote, just cause. It's obviously very important to employees, very important to unions, but that's the provision of the collective bargaining agreement that maybe most worth highlighting, or is the most different from a unionized versus a non-unionized environment. With the just cause provision, it's the employer's burden to prove that a discipline or termination was quote unquote just cause, and with that comes a whole lot of evidence and a whole lot of considerations. Seniority. So seniority is defined in each contract or MOU, and there'll be a particular definition, and it has to do with length of service, how long you've been in the bargaining unit, or how long have you been in a particular position. But there's seniority, the contractual concept of seniority under the MOU goes in as part of many different decisions, or many different provisions of the MOU that affect many different decisions the city or any other employer could make. And almost always, and this is true in the VPOA MOU as well, the employees, you're the sworn officers with the most seniority, they'll get the top preference for it. It could be a promotion, could be moving to a new schedule, could be scheduling your vacation, recall from layoff. That's what recall means, recall from layoff. If there's ever a layoff, getting recalled from layoff. Seniority provisions are very important to unions, generally speaking, in collective bargaining agreements. Other than just cause, it's I guess one of the top priorities of a union to secure strong seniority language. And there is seniority language in all 3 bargaining agreements. And seniority, what's listed in parentheses there is just examples of where seniority comes up. It's sprinkled through the contract in various places where the most senior officer will get preference in a variety of scenarios. There's pay. Most or all aspects of pay are controlled by the MOU, from overtime, holiday pay, hazard premiums, or hazard incentive pay. It's very typical that MOUs govern that, and the MOUs that the city has do govern almost any aspect of pay that you could imagine. Benefits is another big issue. So it could be sick leave, could be medical leave, could be insurance, medical, dental, vision, and of course pension and retirement benefits. Those are governed by the MOU. There are specific provisions in the MOU, and what that means is in order to change something, to change anything that's governed by the MOU, generally speaking, the city and other employers need to wait until the contract is open. And by open, I mean, the last one has expired and the parties are negotiating a new one. You need to wait until that moment to try to change things. And then when you do want to change things, there's no guarantee that you can. You have to. It's all a matter of bargaining. So everything, and the MOU is. I have it up. I mean, it's detailed, and it's many, 60, 70 pages. They vary in length, but it's pretty long and it's pretty detailed. And whatever's in the MOU is set basically in stone until the next MOU is being negotiated. So the life cycle of a contract, I said, like a redwood tree. I guess you could say like an onion, but onions stop growing at some point. What I mean is these contracts get longer and longer the longer the bargaining relationship goes, almost invariably. So, for the city of Vallejo, for a lot of other cities, for PG&E, for the University of California, for employers or cities that have been around a long time, the collective bargaining agreements, most of their collective bargaining agreements have also been around for a long time. And each contract cycle, those agreements tend to get longer and more detailed and cover more aspects of the employment relationship, and to do so in a more detailed way. It is possible, so it's legally possible, and I'm sure it's happened before in the history of labor relations in the United States, to have a set of bargaining result in a shorter contract, a contract that gives management, more freedom to act and less restrictions. It's just very, very rare. When I look at, I can look at a contract, and with that I see the contract, I can usually guess, or at least approximate how long that union has represented employees of that employer. I see a 100-page contract. It's a long time. It's many, many decades is usually my guess. I see a 20-page contract. My guess is, that could be the first contract. Or, maybe the union was certified, 5 years ago. The contracts just tend to get longer and longer as time goes on. As they get longer and longer, that's, it can get harder to read, or at least harder to know every provision of the contract. contracts can get more, tend to get more restrictive and longer as time goes on. And that doesn't mean that the management of the city or the management of any other public or private company can't try to make things more efficient and more streamlined. It's just, if any of you in that room, look through any of the 3 collective bargaining agreements and you're thinking, man, this is long and very detailed, and this doesn't give us much wiggle room. I can tell you it's like that for every other public employer I've seen and every private employer I've seen. If the contracts get longer and more complex as things go on, and that's kind of just what we're dealing with a mature bargaining relationship. You're going to be dealing with a contract that has its tendrils into just about every area of the employment relationship.
So Josh, may I interrupt you for just a second?
Of course.
Thank you. So as you all may be aware, the collective bargaining agreements for the city are available online, and you can peruse through the affected ones here. Certainly, if you do that and you have questions about them, we would be happy to answer them all to the best of our ability. If any of you cannot find the agreements online, we're happy to send them to you via email so that you have those copies available. Ultimately, as we move forward and you are stacked up in your powers and acting, we'll prepare some binders for you that are available at each meeting that essentially have all of the operative documents in them, your ordinance, the collective bargaining agreements, and any other documents that you all feel are important to have in front of you as you take on your role. Thanks, Josh.
Thank you. The second bullet I have on this slide is about the power of the arbitrator under a labor contract and extremely limited court review. So what I mean by that is that there is a principle in the law, and this is true for I use PG&E's example because it's a private company that all of you know, and the University of California because it's a big public employer that all of you know. The city of Vallejo. This is true for all of those employers. This is true for a Starbucks cafe that has a union contract. There is a labor arbitrator, and the arbitrator will be selected under the terms of the contract. Some of them have a list of arbitrators, so 5 people, and it's usually called a panel. And the parties, meaning the union and the employer, will select one of these 5 arbitrators when there's a grievance that needs to be resolved. Some contracts say that the parties are going to request 5 or 7 arbitrators from this kind of a federal database, a service that will send you a list of arbitrators, and you do a coin flip and each party strikes one, meaning I don't like him, I don't like her, I don't like them. You go back and forth until there's one left, and that's the arbitrator that decides pick. I said a word grievance. A grievance is a complaint, is a charge. It's the thing that gets filed under the contract. So a lawsuit might be filed in court. A charge might be filed in front of an administrative agency like the EEOC or NLRB or PERB. In the MOU sense, it's called a grievance. A grievance is a complaint, usually that the city allegedly did something wrong, disciplined someone they shouldn't have, didn't give the most senior officer first dibs on vacation, changed medical benefits in a way that allegedly violates the contract. Any complaint that the city violated the MOU goes through a grievance procedure, but eventually is decided by a labor arbitrator who's picked under whatever the agreed upon manner is. For labor arbitrators under a collective bargaining agreement, it is very, very difficult for either side to get a judge in court to disturb that labor arbitrator's award. That's why labor arbitrators wield so much power. That's why, these things called arbitrations are very important. They're kind of make or break hearings. But a labor arbitrator, when they make a decision, usually called an award, the decision could be this officer was terminated for just cause because of all the evidence of misconduct, that they were trained adequately, that the city doesn't discriminate it, would terminate any officer in this situation. Okay, the arbitrator could say it's for just cause, termination upheld, or arbitrator can find some fault with what the city did and say this person should have gotten a final warning, not a termination, so I'm going to order them to be reinstated with back pay, meaning pay for all the time that they didn't work, but the arbitrator thinks they should work. It's extremely hard to get a court to disturb that arbitrator's ruling. You can't, a party cannot get a court to overturn an arbitrator's decision by convincing the court the arbitrator was wrong. That's not a basis you can get a court to overturn an arbitration award. You would have to show that the arbitrator exceeded their authority under the contract, meaning they did something they weren't supposed to do. An arbitrator can't say, find a new mayor. Arbitrator can't say that under the contract, okay? Because that's not an agreement that governs sworn officers. An arbitrator can do just about anything else under the contract, and it's really hard to get a court to disturb that. I've tried. I've had clients that had really bad arbitration awards. We tried our hardest, had a good case, had a bad arbitration award. I've tried my hardest to get a court to overturn it. It's really difficult. I've seen unions do the same thing. Arbitrator has a lot of power, and that's one of the uncertainties in life governed by an MOU. You think you have everything, the strongest case possible, but the labor attorneys, I guess, who've been through this, and the folks who've been through this many times may tell you, hey, based on experience, we've actually lost this in front of a labor arbitrator, and it may not make sense, but labor arbitrators kind of have that power. The point of the law around this, I guess, is to kind of keep disputes out of court. If there's a benefit to it, it's that it keeps disputes out of court, and labor arbitrations are usually quicker than a lawsuit, so that's good. But what you give up, you kind of give up the right to actually, you can't go to a court and say, look at all this anew. Start fresh. Judge and jury, we want you to look at it because the arbitrator got it wrong. Arbitrators sometimes get it wrong, and they have that authority under the MOU.
So Josh, we have a question from one of our commissioners.
Absolutely.
Hi, Josh, this is Renee. So isn't there a step in between when a grievance is filed and then going to an arbitrator? That's usually a last resort. Am I understanding that correctly? And the other question I have is that something that the VPOA does regularly, is go straight to an arbitrator instead of trying to settle it at the lowest level possible?
The first question I can answer, Renee, and then I'll probably defer to Veronica and Randy for the second one. There are different steps of the grievance process. You're absolutely right. The grievance is the first step. Arbitration is the last step. And the contract, the MOU, contains various steps that are designed to flesh out the allegations and provide an opportunities for the parties to settle short of arbitration. And that's definitely there. So that's a good point.
I'll answer the second question.
Is there any way that can be referenced in this PowerPoint, because it makes it look like you go straight from a grievance straight to an arbitrator, when I know there's always a means to try and resolve it at the lowest level possible? That's what I was just wondering.
Right. So we have for the grievance process itself under the MOU, we have a 3-step process.
Okay.
So it goes through each of those, potentially goes through each of those steps, though that can be a quick process, meaning if you can't reach resolution at any of those steps, it advances relatively quickly to arbitration. The answer to your second question, which was sort of the frequency of the arbitration process here in Vallejo with this bargaining unit, I guess, Randy can help me out and weigh in on this too, but I would say relatively frequent. That we are not able to resolve at any of the lower grievance steps, and we end up at arbitration. But it depends on the severity of the question and issue. So, little issues, I think, that tend to be, one-offs, not affecting salary or assignments or advancement. I think those are more likely, or have tended to be more likely to resolve at one of the earlier stages. And as you could probably predict, issues surrounding, salary, discipline, so serious discipline, those tend to get appealed to arbitration. And also anything that affects pay, the way pay is categorized, those tend to go through that as well as sort of working conditions that may be believed to be outside the scope of the MOU or policy.
Okay, thank you.
You want to add to that?
Sure. At least since I've been here, I'm counting 4 arbitrations that went all the way to hearing. There were some others that got started that got resolved along the way before it got that far. So that does happen.
To you, Josh.
Okay. So this slide is the intro to has some points about the Act, the Myers-Milius-Brown Act, or the MMBA, and PERB, the Public Employment Relations Board. The MMBA, I think I mentioned this in the intro, but it's the law that gives city employees collective bargaining rights similar to what was granted to private sector employees earlier on. So the National Labor Relations Act is dated in the 1930s. The Myers-Milius-Brown Act was decades later. At this point, I believe all 50 states have public sector collective bargaining laws, but it wasn't always like that. Well, originally, no states had public sector bargaining, collective bargaining laws. It was in the 20th century after the NLRA or the Wagner Act. So, post World War II, when these laws started getting passed. California was pretty early in the uptake. New York State was another state that was pretty early in the uptake of bringing, private sector style collective bargaining to the public sector. There's different laws that govern the University of California employees, school district employees. So the public school district in Vallejo is actually governed by a different law called ERA. It's the Education Employment Relations Act. And I may be getting it, maybe educational. Trial courts, like actual judges, state courts, their staff are governed by a different law. And the state itself, state employees, from CHP officers to prison guards, they're governed by yet a different law. They function, I'll say they function similarly, although there are some distinctions, but it gives city employees the right to form a union or join a union. VPOA is just a City of Vallejo union. IBW is an international union with many different wings, and the MMBA gives employees the right to choose either to form their own union that's specific to the City of Vallejo or have choose an international, larger union like the IBW. The purpose there, that's not my purpose, that's the stated purpose in the statute, to promote communication and improve relations between public employers and employees by providing a method for resolving disputes on wages, hours, and other terms and conditions of employment. that's the purpose. Sometimes that's true in practice. Other times it can be the case that their relations are tough, our relations are difficult, and there's no one right answer. It's not a bright line. It's not always one case or the other, but depending on the union rep, depending on what's at issue, sometimes unions make it harder to have relations between public employers and employees. Sometimes they make it easier. The law is supposed to make it easier. The Public Employment Relations Board, or PERB, has 5 members. They're appointed by the governor. All 5 members now were appointed either by Governor Newsom or Governor Brown. As time goes on, the last appointees of Governor Brown, they will have their terms expire and they will all be Governor Newsom appointees. This is true in the private sector as well, where the National Labor Relations Board in Washington, D.C. has its members appointed by the president, where depending on who gets elected to the White House, the rulings of the board will change because they're going to appoint people who are kind of on their side of the political spectrum. The Public Employment Relations Board is similar in the sense that, different people, with all their, everyone's got kind of a leaning, right? People try to be neutral, but, some people have different views than others. PERB can swing a little bit more pro-employer or a little bit more, pro-union or anti-employer or hostile to employers' actions, depending on who appoints the board members. The current Public Employment Relations Board is very, union strong or very pro-union. Its members were appointed by Governor Brown or Governor Newsom. Their board members, I think 2, maybe 3. There's at least 2 board members who, they've bright people, good people, but they made their careers as union side attorneys, and I've been up against them in arbitrations, PERB hearings. Now they're on the board, so now they make the rules, and they're certainly experts. Board PERB members are certainly experts in labor relations. They have all the expertise I do. Some of them have more, but they're going to come from a union background or a pro-union background, just because of the politics of the situation and who appoints them. So what we're dealing with now is a Public Employment Relations Board that tends to be pro-union and skeptical sometimes of things management does or management will do. PERB, so an arbitrator, when we talked about an arbitrator, a labor arbitrator selected under the contract, if a grievance doesn't settle, is going to decide issues under the MOU. Did you violate that seniority provision? Was this person terminated for this very high just cause standard, or should they be brought back? Did you make a change to your medical insurance carrier that wasn't authorized by the contract? That's a labor arbitrator. The Public Employment Relations Board, I put in here, handles unfair practice allegations. So any sort of conduct that violates the law, which is different than violations of the contract. Public Employment Relations Board would not be the one to decide whether someone was disciplined for just cause. The next slide has a little bit more about what PERB's powers are. The last slide says power of PERB, deferential court review. It starts if there's a complaint against the city or a complaint against a union. It starts at a local level in front of charges filed. The first hearing would be in front of someone called an administrative law judge. Sometimes called an ALJ, It's a judge of the agency. There could be a hearing, witnesses, evidence. That administrative law judge would make a decision. Either party, the union or the employer or an individual employee, individual workers can file charges with the PERB also. But any of those, whoever loses in front of the administrative law judge can appeal to the board. And when I say the board, I mean PERB, and that's all 5 members on the board. Once PERB makes a decision, that decision is final unless a court steps in and disagrees. Courts usually 9 times out of 10 will agree with PERB, whatever PERB says, because they will say, look, PERB is the expert agency on labor relations, and we're just a court. You know, we do all sorts of things, criminal matters, wage disputes, whatever, right? PERB is the expert agency on employment. It's not quite as hard to get a court to review a PERB decision as it is to get a court to review an arbitrator's decision. But it's still pretty hard. These are the courts don't, you can't just go to court and say PERB got it wrong, so we want you, judge, to disagree with PERB because PERB got it wrong. It's a higher standard than that. PERB has a lot of power when it comes to public sector labor relations. This is it's not labeled here, but these are things that PERB handles. So these are things that a union, union, employer, or employee, but 9 times out of 10, again, it's a union that will file one of these charges. These are things that the union can bring to PERB and say, hey, PERB, starting with an administrative law judge, the employer did something wrong. City of Vallejo allegedly violated the law. The first bullet, so if there's alleged discipline or termination or another, I guess, adverse employment action, a demotion, a transfer to some undesirable assignment, and the allegation is the reason that the city did that is because that officer, I'll just use a VPOA as an example, that officer stood up for the union, said something supporting the VPOA, or stood up and said, hey, we all of us officers were being overworked and underpaid. If the officer made a statement, even if it was just the individual officer, that was about collective working conditions for all officers, or wages, or working hours, you can bring that allegation to PERB and say, look, I was retaliated against for protected activity. To do that, you need some evidence. You need some evidence that that what the city says was the reason that you were disciplined is not the real reason. And it's, in fact, it's retaliation for standing up for the union or standing up for other officers. But this is a charge you can bring to PERB. And the PERB is, it's kind of there to protect the unions and unionized workforce. So if you have any evidence at all, this is that, you may see a charge brought to PERB that, hey, I was retaliated against for protected activity, for speaking up for my union or speaking up for my fellow employees. The second bullet, and this is what's, well, the union can bring a charge to PERB and say that the city failed to bargain in good faith. And that's, that term has many, it's a multi-headed creature, not bargaining in good faith, or allegedly not bargaining in good faith. It could be the actual process of bargaining for a successor MOU. It also could be responding to requests for information. What I mean there is the union has a right under the MMBA to ask the city to provide information on the officers employed, the reasons for discipline, what the city spent on medical insurance for officers, all manner of things. And the city is a pretty liberal standard, meaning expansive standard, where the city or any employer has to provide information when the union requests it. That would fall under this broad bucket of failing to bargain in good faith. If there's an issue, medical coverage, or scheduling, how officers are scheduled to particular shifts, or some rule of conduct that's not in the MOU, but it's a city rule and we want to change it. Usually, and there are exceptions, which we'll get into, but very often the city has an obligation to tell the union about it. It's called providing notice. This gets into the second bullet, this decision versus effects or impact bargaining. If the city wants to make any change at all, very often the city has an obligation to do one of two things after you tell the union about it. Decision bargaining are issues where the city can't make the change at all without negotiating with the union about it, and either coming to an agreement or reaching something that's called impasse. One example is, look, the standard for discipline. If let's say that there's lots of good reasons that come up, and there's studies and the various good reasons for saying, let's just change the disciplinary standard from just cause to fair and reasonable, because just cause is too high of a standard. And we want to, we're just concerned that just cause doesn't allow us to terminate an officer that should be terminated. We want it to be fair and reasonable, or fair and non-discriminatory, not just cause. Just cause is too much. The city can't just do that. The city would have an obligation to bargain with the union to agreement, since there's a contract that says just cause, before the city can make that decision. Effects bargaining or impact bargaining refers to a situation where the city has the right to make a decision. One example would be, in most cases, layoffs. And this is a hypothetical city. Let's say a city decides that it's going to decrease its police force by 50%, because the city's going to put more money into fire protection, because there's a lot of fires in that city, but no crime. Okay, this is made up, but the decision of, okay, as a city, we're gonna have a smaller police force, and we're gonna have a firefighting force that's twice as big. That's normally a decision that an employer, including a public employer, can make, because the city's responsibility for kind of managing its own resources and deciding what services it's going to provide. But the city can't do that, what's called unilaterally. It can't do that on its own without telling the union about it and engaging in what's called effects bargaining. And effects bargaining, or impact bargaining, like the term suggests, would be discussing and bargaining with the union about any effects that might have on police officers. And there would be a ton. There's a lot to discuss there. There'd be a lot of meetings, a lot of requests for information. The union would say, what do you give us all the documentation, all the studies you've done that would justify decreasing the size of the police force and increasing the size of the firefighters. Let's talk about exactly who's going to be laid off, to make sure that there's still enough officers out on the street and officers doing other stuff they need to, not on the street. Let's talk about who's getting severance. Let's talk about how schedules are going to be impacted. Let's talk about how workloads are going to be impacted. Let's talk about all the additional overtime and how you're going to deal with that. Let's talk about officer safety, because if there's fewer officers on the street, officers are going to be less safe. So you could have a decision that the city's allowed to make, but all the effects on employees would still have to be negotiated about in what's called effects bargaining. And effects bargaining can be just as involved, just as kind of intense a process, can take just as long as decision bargaining. They have to be done, and they have to be done up to PERB's standards. So they have to be done fairly. If the union makes whatever the city wants to do, if the union makes a counter proposal, even if we think it's ridiculous, even if the city says that is not a serious counter proposal, it's not going to work, it's impractical, it's impossible, the city, the public employer, has to sit down and discuss that proposal, has to go through the reasons why we disagree with that proposal. And you have to talk about all the issues. If there's on something like a layoff, I listed 10. I think there's probably more issues, okay, from safety to workload, to scheduling, to how that impacts seniority. You got to bargain about all those effects. And if you don't, or if you allegedly don't, that's where PERB comes in. And this is the type of charge that employers see, in my experience, very frequently. The charge is you didn't do all that you need to do in bargaining. You didn't answer all our questions. You stopped meeting with us when we were still making progress. Progress was slow, but we were still making progress, and you unlawfully stopped meeting with us. The PERB charge would allege the city, any of the unions, including VPOA, can file a PERB charge and allege the city didn't bargain in good faith. And they would ask PERB to order the city to keep bargaining, go back to the drawing board, or you don't have to throw it away. Go back to where you were before you made that change, and keep bargaining with the union. The union would seek what's called a status quo order. So PERB would say, go back to where you were before you made that change, and we're ordering you to bargain some more with the union. It makes it, in effect, it can make it hard, can make it a hard and long process to do just about anything. And that's, doesn't mean it's impossible. It just means there are the union has a lever in PERB to kind of put the brakes on what management is doing by alleging you didn't bargain in good faith. Either you didn't engage in decision bargaining, and where the union says allegedly we had to, or you didn't engage in enough effects bargaining. There's a term called impasse. So impasse, fact-finding, mediation. Those are impasse means if the union and employer are bargaining about something. This would come up most typically in when a contract is open. So when one contract is expired, but the next one hasn't been finalized yet. Impasse means that there's both parties are on their final positions. We made a move, union made a move, we made a move, union made a move. And neither party has any more moves, but there's still no agreement. And so we're at impasse. One party or the other can say, hey, we're at impasse. The other party may disagree and say, we're not at impasse. We were still making progress. I had this proposal. I had the proposal that we were about to make, so we're not at impasse. The impasse resolution procedures, which can be triggered on the request of a party. And in my experience, a union would usually trigger these procedures rather than allow a city or an employer to take action. But there's one is mediation. Mediation is just what it sounds like. There's a mediator. It can be appointed by PERB, or parties can pick out of a panel that the state mediation and conciliation service will send. Mediator doesn't have real authority, but they kind of bring both parties into a room and see if they can find a way to bridge the gap between the two parties' positions. And fact finding. Fact finding is there's someone called the fact finder who will take arguments from both parties. The union comes in and say, well, here are the reasons why the city should give us this much in wages. The city should not cut our pension, and the city should give us this proposal that we wanted on officer discipline. And the city comes in and says, well, here's the reason why it makes the most sense to have the wage increase be this much instead of what the union wants. Here's why our proposal on a pension is the best way to ensure the long-term survival of the pension plan, but still reward long service employees. And here's why our proposal on employee discipline is fair and will ultimately benefit everyone in the city. And a fact finder will issue a non-binding report saying what that fact finder believes is the best position on various issues. It's non-binding, but it's also not private. It's public information, and it's generally a benefit to whatever party the fact finder agrees with. So if there's a specific issue in bargaining that's under dispute and the fact finder agrees with the city's position, generally, and this depends on who's reading it, and what people living in what the constituents think about the issue. But generally speaking, it's good politically if a fact finder agrees with you. Unilateral implementation, if bargaining doesn't always result in an agreement. If you have an agreement, both parties sign, and that is the contract for the next 3 years. Could be 4, could be 5, could be a shorter period of time. 3 years is 3 or 4 years is both relatively normal. That's what happens if you get an agreement. If the parties don't get an agreement and they're at impasse and they go through, let's say they go through mediation and fact finding because one party requests it, it's possible for the city or any public employer to unilaterally implement. That means here was our last best and final offer. We bargained in good faith for a year or 2 years. We went through mediation, we went through fact finding, we're at impasse. The union won't agree, but we are going to unilaterally implement, meaning these are the changes. If all those things, if all those things are true, meaning if an employer can prove that they bargained in good faith, that there was, I guess, a true impasse, meaning there was no chance the parties were going to come to an agreement, then it is an available tool for an employer to unilaterally implement some things that whatever the last best and portions of the last best and final offer, whatever the city, the reforms, let's say, a reform to a discipline system, whatever reforms the city has proposed. So unilateral implementation, where that comes in, that is a tool for an employer that an employer can use. PERB, where PERB comes in, and then why this is under the failure of an employer to bargain in good faith, where PERB comes in, is that inevitably when an employer, public or private, does that, meaning does a unilateral implementation of its final contract offer after bargaining for a year or 2 years, or whatever the case may be, the union will file an unfair practice charge with PERB and try to poke holes in something the employer did. So allege that the employer didn't sufficiently consider a counter proposal the union made. And the employer just rejected it out of hand and didn't sufficiently explain, or the city didn't sufficiently explain its reasons for rejecting the union's proposal. Or, back on October 17th, 2023, the union asked for information at a bargaining session about the average percentage increase in officers' pay for the last 20 years. That's just an example. The union asked for some piece of information, but the city didn't respond. And there's that piece of information the union asked for, but the city didn't respond, and therefore the city engaged in an unfair practice and violated the law. And therefore, the contention may be the city didn't bargain in good faith. There was no there was no lawful or bona fide impasse, and therefore this whole unilateral implementation has to be rolled back. There's a lot of, someone filing a charge of PERB can throw a lot at the wall and see what sticks. But that's I guess the path that an employer has to walk if an employer wants to engage in this unilateral implementation. Meaning, if you want to make any reforms to the current contract without the union actually agreeing, you got to walk this path of bargaining to impasse, going through fact finding and mediation, most likely, doing a unilateral implementation, and then defending all that at PERB, which is tends to be these days a pro-union venue. So that's what unilateral implementation means. It is something that the law allows the city and other public employers to do. It's just a hard window to climb up to, and the risk is, if you're about to unilaterally implement a final proposal, is that PERB, a year or two down the line, will tell you did it wrong. You need to go back. You shouldn't have, whatever you did, if you laid off officers or you changed the disciplinary or investigatory procedures, and that might have resulted in additional officers being terminated or disciplined. Whatever you did, city, you got to undo it and hire those people back and provide back pay and make people whole for any benefits they lost. If PERB finds that you didn't bargain in good faith, PERB can 2 years later require the city or any other public employer to kind of go back to the way things were. Strikes I put there. Not all employees have the right to strike. Public employees generally are not prohibited from striking, but police and firefighters, and there are some other classifications are. So this is, in terms of this meeting, I don't think strikes are a big issue. PERB handles strikes, so it could be the University of California nurses who are striking, IBW. I think if they could have a theoretical dispute with the city and strike, and PERB would handle disputes about strike rights and kind of what happens based on that. I think one of the most complex concepts in the MMBA, and it's similar under other public sector laws. So it's a complex concept in PERB rulings, because the PERB issues rulings, kind of like courts issue rulings, and then those rulings become precedent, and a precedent in a decision that PERB issues this year, it's supposed to apply next year if something similar comes up. So over the years, PERB issues many decisions. Those decisions kind of become precedent. And then later on, if a city is trying to figure out what to do we need to bargain with the union about this, or can we go ahead and do it on our own? You look at PERB precedent and try to figure it out. There's a concept called the scope of representation. And as shown here, that is if it is within the scope of representation or inside of the scope of representation. Scope of representation was a ball. If it's inside that scope, the city has to bargain with the union before changing it, before changing anything in that realm. Wages are definitely within the scope of representation. The city can't give an officer a pay raise, no matter how good they are, without bargaining with the union. The city can't cut an officer's pay, no matter how poorly they perform, without bargaining with the union. If there's a provision in the MOU that says the city may decrease an officer's pay if they do X, Y, or Z, then the city could do it. But that's because it's in the agreement, in the MOU. You can't do anything essentially with a pay rate without bargaining with the union. That's easy, meaning we know that that's within the scope of representation. There are other issues where it's not so clear. The definition in the law is the first indented bullet here. The scope of representation, this is what the MMBA says, includes but is not limited to wages, hours of work, and other terms and conditions of employment, but excludes consideration of the merits, necessity, or organization of any service or activity provided by law or executive order. And the bullet says, what does that mean? Okay, so includes means those are the things that you do, that the city does have to bargain about with the union first, cannot act unilaterally. Doesn't matter if the mayor and the council and all of you and 90% of the people who live in Vallejo agree on something. You can't do it without bargaining with the union first. That's what it means to be within the scope of representation. Excluded means something the city can do when the city decides to do it. Merit, the merits, necessity, or organization of any service or activity provided by law or executive order. I've probably read that 100 times in my career, maybe more. Similar phrasing in some of the different laws. And I don't know what that means. Without, all I can tell you about what it means is we need to look at what PERB or the courts have decided it means and look for guidance from the cases that have issued over the years that have decided what this means. And I'll go through some examples. This gets dense, but there's no way to I don't think there's a way to make it anything other than dense, because you've seen the definition in the law, and the legislature, the California legislature, didn't give a whole lot of direction here. So I'll talk about a few cases on this issue. And so the font gets a little bit small, but there's a Supreme Court case called the Claremont Police Officers Association. It was 2006 when the decision came out. The issue was the scope of representation under the MMBA. The Supreme Court held that there's no requirement to bargain the decision to implement a study about racial profiling. It was directed at figuring out the extent to which racial profiling was going on. Required officers to fill out a questionnaire when they made traffic stops. Asked the officers to answer certain questions. The city thought that the answers to those questions would tell it about the extent to which officers were engaging in racial profiling. In that case, there was no evidence at all of any connection between the study that the city was requiring officers to participate in and officer discipline. That was important to the result. and there was no holding about effects bargaining because there was no evidence of any effects at all. So this decision talks about something that the city of Claremont was allowed to do on its own without bargaining with the union. So the city was allowed to tell officers, hey, spend a few seconds or a few minutes filling out this questionnaire when you make traffic stops. Because we, the city, we want to study, we want to look at racial profiling, because for various reasons, we think that's an important issue for us to know about. And the Supreme Court said it's okay to just do that. You don't need to bargain with the union. When this decision came out, there's some language in it that I have, clients, public employer clients who are kind of looking for decisions from a court that would allow them to act decisively when they need to. This decision came out. I think it was viewed by many as a good decision, at least a good decision for management of a city, a police force, to be able to kind of take some actions. Especially if you want to address problems caused by racial profiling, just go ahead and do it and not have to ask the union's permission. Sounds great. But the limitation here, why I think it had kind of a limited effect is the discipline issue. So if you read the decision, it's very clear that there was no discipline. No one was disciplined. The city wasn't, I guess, disciplining officers for not filling them out. Wasn't disciplining officers for not filling them out well enough. It wasn't connected to discipline. And then there was really no evidence that had an effect on any officers at all. Because if you recall, there's the decision and effects bargaining. Even where a city has a right to make the decision to do something. So I'm going to do this. If there's any effect at all on employees, you have to wait until you bargain about the effects. So it was kind of a pro-management decision, but it's very limited because you have something that didn't involve any sort of discipline, and it wasn't a rule that you could be disciplined for violating. And there was really no evidence of any effects at all on officers. And if you think of, major things or important things that you may want to do, that the city may want to do, that the mayor or council may want to do, most of them are going to have some effect on officers, right? So this is a decision that's out there, but it's kind of limited because the court said, hey, there's no effects. Court of Appeal, this is a second level court. An appellate court. It's also a court that has a lot of authority. In 2020, the decision I think was 2022, but Los Angeles deputy sheriffs versus the county of Los Angeles. The city of Los Angeles was faulted for not engaging in effects bargaining. And this was a 2021 law that required law enforcement agencies to maintain policy prohibiting participation in law enforcement gangs, and to authorizing revocation of certification for serious misconduct, including participation in law enforcement gangs, or failure to cooperate with an investigation in potential police misconduct. So there's a state law requiring cities law enforcement agencies to maintain a policy prohibiting law enforcement gangs and to take some action to prevent law enforcement gangs, to figure out where you might have law enforcement gangs. So that's pretty clear. City has to act. City has to do something in response to this law. What the city did, they had they undertook their own investigation, including interviews that officers had to sit with. The sheriffs or the county had whatever reasons it had. I'm sure it had some facts. It knew something about some of these officers. It decided based on certain facts, it believed it had to call certain officers in for interviews, mandatory interviews. come talk to us. We have some questions about your tattoos and other things that make us believe that you officers are affiliated with a law enforcement gang. The city didn't bargain with the union before doing that. The city believed, look, this law was passed that requires us to maintain a policy prohibiting participation in law enforcement gangs. If you violate that policy, it's ground for termination. So we're the county, we're going to comply with that law, and we want to comply with that law because we supported the law. But so we're going to do it. And how do you do it? Well, you investigate. You bring in officers for interviews on paid time. You bring them in for interviews. The county got dinged for that because the law that was passed, if you read the text of the law, it prohibits law enforcement gangs. It requires cities to have a policy prohibiting law enforcement gangs. It says if you participate in a law enforcement gang, you can be terminated. But the law doesn't say, here's how the interview process should go. Here's how counties should interview people. Counties should interview everyone who has certain kinds of tattoos. The law doesn't say that. The law doesn't go into that much detail. That's something that, even though there's a law that says that law enforcement gangs are prohibited and you, the city, have to have a policy prohibiting law enforcement gangs, the law didn't address how you're going to do it. How are you going to go? How are you going to select people to interview? What's the interview process going to look like? Is there going to be a warning? Like a warning system. Hey, I see you have these tattoos. I have seen some social media posts, but immediately stop your affiliation with this law enforcement gang. Otherwise, you'll be terminated. Should there be like a warning system, or should there be immediate termination? All of those things were held to be effects that must be negotiated. So that's a good illustration of, I think, the requirements and the steps that a city or a county law enforcement agency has to go through with the union, noticing the union and effects bargaining with the union, even for a state law that mandates something, that mandates, hey, you got to have a policy prohibiting participation in law enforcement gangs. There's still effects bargaining obligations that the city or county has to undertake. There's a few more examples here. The subject, this is kind of some more examples on the subject of just examples of management directives that impacted discipline that triggered the meet and confer requirements. But when I say meet and confer requirements, I mean duty to engage in bargaining with decision bargaining with the union before implementation. And so the Holiday case and the Vernon firefighters case, I picked those out as examples. Those are pretty clear examples to me of things where I would say if the city of Modesto or city of Vernon had asked me, hey, do we have to bargain before we implement mandatory drug testing that is above and beyond what any minimum legal requirements, even if it's a really good idea to have mandatory drug testing, even if we've had problems with officers and substance abuse, I would say, yeah, it has an impact, a direct impact on employee discipline, could cost officers their jobs. You absolutely need to meet with the union and bargain with the union before you implement that. The Vernon case, a disciplinary rule prohibiting employees' use of facilities for personal purposes was subject to bargaining. I mean, it makes sense. It's city facilities, personal purposes. City facilities should be for city business, right? But what I gather, when I reviewed the case, it's not in this little what's called a parenthetical, is that that rule wasn't always enforced. So even if it makes perfect sense, obviously city facilities should be for, like, firehouse should be for firefighters who are either on standby or actually preparing to fight a fire, not for personal purposes. If it was a change in what you did before, and the city employee can be disciplined for it. If it's a change in a rule and you can be disciplined for it, you generally have to bargain with the union before you do it. The city of Palo Alto decision is it's not a disciplinary decision. It's kind of it's another kind of angle on this scope of representation issue. But a city or other public employer can have bargaining obligations with the union, even if it's not directly a city action. This was enacted, the city of Palo Alto was sponsoring a ballot measure, repealing a provision that required binding arbitration upon impasses in negotiations. So what was at issue there is the city was going to say, let's put it to the voters. Let's let the voters decide. But it was still the city putting something forward that could affect city employees. And what the city was trying to do is go back to a situation where the city could unilaterally implement if there was an impasse in bargaining. Apparently, in the city of Palo Alto, there was a provision in the city municipal code that didn't allow the city to unilaterally implement its final proposal in bargaining. Instead, said, "Hey, arbitrator, you'll decide whose proposal is right." So the city wanted to change that. Said, "Well, we're not going to change it directly. We're just going to put it on a ballot initiative and let the voters decide." But even that, the city is required to provide notice to the union and bargain before doing that. This last case and the examples, and there's say it's not an exaggeration to say there are hundreds of different cases on what is and is not within the scope of representation. But City of San Jose, San Jose Peace Officers Association, this is an illustration of a matter that the court, and you may be asking, why are there so many court decisions on this issue? There was a time period where courts and not PERB decided MMBA issues like this one. So there was a time period when there were a lot of court decisions on the MMBA. But under the MMBA, when the city of San Jose changed its use of force policy in a fundamental way, so from on when an officer is allowed to use lethal or non-lethal force on a prospective basis, and it reflected a shift toward. I mean, in that case, I've read the prior policy and the policy that after the city changed it, and I'd say generally speaking, it had more steps that officers were to consider before they used force. So it was a city's decision to shift slightly away from a immediate use of force. The court there said, okay, the city's allowed to do this because this is a fundamental managerial decision, not subject to bargaining. It's a matter of public safety and a fundamental managerial decision, not subject to bargaining. So again, I know this gets a little dense. And on the other hand, you're talking to a lawyer who said he was an expert in this area, so I guess I should know. Or you may be thinking I should know, but I don't know. I can't explain to you why, in this case, so City of San Jose, why the court said, look, the use of force policy, a change in the use of force policy that applies to all officers, where the city's trying to move in the direction of a more restrictive use of force. So the city is allowed to do that and doesn't have to bargain with the union about it. Why is that the case? But the county of Los Angeles, over here, wasn't allowed to unilaterally decide who they're going to interview when there's a law that says you got to prohibit law enforcement gangs. So why couldn't the county decide who they're going to interview? Isn't that a matter of public safety? And isn't that something that should have been within management prerogative? Well, I mean, that's what the county of Los Angeles attorneys were arguing. My point is, or one of my points, is that there's a lot of gray area here in terms of what is inside the scope of representation and what isn't. What can the city do on its own without the union's permission, and what can't the city do? Personally, I think it's frustrating, and I don't run a city. I don't run a county. I don't run a state. I don't run any business at all. I've just been through these considerations with clients over the years. In the public sector, in particular, it's incredibly frustrating because of how gray some of these issues are. But in terms of what I wanted this group to understand, there's a lot of law, there's a lot of cases on this that go both ways, and if there's any particular initiative or reform that is just a super good idea, there's lots of things that kind of need to be considered. Working through the city and the city's council who've been down this road many times. Things that need to be taken into consideration before an action can be taken, even if it is 110% the right thing to do. There's things that need to be taken into consideration, whether it might violate the MOU, in which case the labor arbitrator is going to ding you for it. So you may need to wait until the next set of bargaining, or whether you can do it, just go ahead and do it, or whether you need to pump the brakes and provide the union notice and an opportunity to engage in effects bargaining. As in some cases, that may be frustrating if there's a particular measure or reform that kind of needs to be done. But the danger, because it's such a gray area, the danger of getting it wrong is you may have a court a couple of years later, court or PERB say, sorry, that thing you did to try to root out law enforcement gangs, the thing you did, you gotta take it back. You gotta run it back. You gotta bring all those people back and redo it because you didn't offer the union a sufficient chance to engage in effects bargaining. So that's the end of the slideshow. I can, and I have time for any questions. We can pull some slides back up again, but thanks for bearing with me through that.
Thanks, Josh. I think we'll see if there are any questions from the commission or any individual commissioners first. Not seeing any. No. Okay. Do any members of the public have any questions that they would like to ask? Okay, seeing none. I'm sorry, ma'am. Would you like to step up to the microphone, please? I don't think it'll show up on the tape. You can have this if you'd like it. Here.
Thank you. My question is, are there written records that can be referred to in the case of having to do these, I'm sorry, I forgot exactly what the word was. Yeah, so once somebody goes in front of a board or a meeting, I'm not really following everything exactly.
I think what you're asking is, if I can restate your question, is are there court decisions and we get opinions from the court that are handed down and placed into opinion in writing. Is that true for all of the bodies that may hear it, either an arbitrator, PERB, or a court? The answer to that generally is yes. And that's part of what guides us as we go forward into the question of if we're looking at something prospectively, like before we make a decision as to whether we can or cannot go forward without having those meetings with the union, we do look at those items. We look at them ourselves, we look at them through special counsel as a way of making sure that we're not either being too, for lack of a better word, liberal and risk-taking, or too restrictive and not moving forward as quickly as we maybe could. So we do evaluate that by looking at those written decisions.
Thank you for restating my question. I appreciate
Was it
that.
accurate? I hope. Thank you. Any other questions? Okay. So thank you, Josh, for joining us this evening and for your presentation. I know this is a bit of a dry subject, but it is definitely relevant to what your actions ultimately will be on this body. So I want to thank Josh for being here and making this presentation. On to your next item on the agenda, which is future agenda items. The next presentation that you will be receiving, as I think the commission is aware, but the public may not be, is on March 26th, which will also be at 6 p.m. In this room. The topic in this room? Did I make that? I think maybe it was the council chamber, and I think. Thank you, Commissioner Jones. It was out of my mouth, and then I realized that's correct. That's the room that's available that night. So March 26th in the council chambers. The topics will be principles of constitutional due process, administrative hearings, the police officer procedural bill of rights, and confidentiality of police officer personnel records. And that presentation will also be made by a expert in those fields. We will have that presentation that evening, opportunity for you to ask questions, as well as we had tonight with the opportunity for the public to ask questions. So with that, if there's not anything else, and it doesn't look like there is, we will stand adjourned. This is off topic, but for any of you who have missed any of the trainings at all, they are available online, but feel free to send us an email if you would like to receive them, the PowerPoints and the videos, presentations, that you want us to send you a link, and we'd be happy to do that to make it easier for you. So just let us know if you've missed any and you'd like that information. We'd be happy to provide that.